Hafa and welcome to the Guam Congress Building. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Wednesday, April 19, 2023, and the time is about 3:04 p.m. In compliance with the open government law, notices for these public hearings was published in the Guam Daily Post and posted to the Government of Guam Public Notice portal on Wednesday, April 12th and Monday, April 17, 2023. Notices were also sent by email to all senators and all main media broadcasting outlets. This hearing is being live streamed via the Guam Legislature's YouTube channel. The general rules of conduct are pretty much just that individuals testifying shall first be recognized by the chair. Please state your name for the record because we are going to transcribe these proceedings. So we have two items on our agenda today. One is Bill number 87-37, COR, introduced by Senators Sabina, Flores, Perez, and Senators Chris Barnett. It's an act to add a new Article 2 to Chapter 16, Title I, Guam Code Annotated, relative to creating a mechanism for attorneys to evaluate and propose updates to Guam's Uniform Commercial Code. It was introduced on March 31 and referred to the committee on April 4th. The second item on our agenda is Bill number 51-37 COR, introduced by Senator Christopher M. Dueñas. It's an act to add a new sub-Article 3 to Article 1 of Chapter 61, Title 21, Guam Code Annotated, relative to allowing the construction of accessory dwelling units in residential zones. This bill was introduced on February 17th and referred to the committee on February 21. I'd like to acknowledge the presence of my colleagues. We're going to be Senator Sabina Perez, Senator Chris Barnett, Senator Tom Fisher, Senator Jesse Lujan, and Senator Chris Dueñas. Those Masi senators for joining me today. So we'll begin right away with the first agenda item, and I'd like to ask the sponsor to introduce the bill.
Therese, Madam Speaker, the Uniform Commercial Code is a comprehensive set of laws governing all commercial transactions in the United States. It is not a federal law, but a uniformly adopted state law. Uniformity of law is essential in this area for the interstate transaction of business. Because the UCC has been universally adopted, businesses can enter into contracts with confidence that the terms will be enforced in the same way by the courts of every American jurisdiction. The resulting certainty of business relationships allows businesses to grow and the American economy to thrive. For this reason, the UCC has been called the backbone of American commerce. Although the UCC of each state are substantively similar, there are usually slight variations, especially for terminology because of the terms used in the state's codified laws. Guam adopted the UCC in April of 1977, or 46 years ago. None of the Uniform Laws Commission's recommended amendments or revisions have been enacted since that time, and so the UCC remains unchanged to this date. Bill 87-37 designates the compiler of laws with the authority to supervise the creation of the proposed amendments to update the UCC to bring it to current and also keep it current as future updates from the Uniform Law Commission are proposed. The Office of the Compiler of Laws is the successor to the Guam Law Revision Commission. All 50 states have law review or law revision boards or commissions to recommend future updates or revisions to state law. It is fitting that the compiler of laws be delegated this authority with the full commitment of financial support by the legislature. The bill allows the compiler of laws to convene one or more panels of Guam practicing attorneys in the form of ad hoc advisory councils to draft proposed recommendation for updates. Although updates proposed by the Uniform Law Commission are all published and available at any time for states to adopt, the precise language of amendments and, more importantly, the effective dates of these amendments are highly complex and require the complete support of nearly all attorneys engaged in the practice of commercial law. I look forward to the testimony and recommendations on this bill. Therese
Masi, Senator Perez. We have several people signed up. If I could invite them to the table to please testify. We have former Judge Elizabeth Barrett Anderson, current chairperson of the Criminal Injuries Compensation Commission. We have our acting Chief Prosecutor Heather Zona of the Office of Attorney General. And we have our compiler of laws, Geraldine Cepeda from the Judiciary. Welcome. Thank you for being here.
Good afternoon, Speaker. If I may start.
Please.
Thank you. My name is Geraldine Cepeda. I'm the compiler of laws. I have submitted written testimony regarding this bill expressing my concern, but I'd like to preface that by first commending the need and the recognition of updating the Uniform Commercial Code, especially in the last few years. The idea of commercial transactions, the changes that have been profound since the first inception in the 50s and 60s, and in the last few years with e-commerce, I can't think of a more important goal. My issue, however, is glaring in terms of what is missing, and that is funding. The funding that I don't see in the proposed legislation to support the work, the intense scrutiny, and the analysis that would be required, and quite obviously the impact on my staff. This is a huge project. The UCC, and I'll admit casually, I do have PTSD from the UCC from law school. It is not my wheelhouse at all. And I do know for a lot of practicing attorneys, this is not their wheelhouse. So to expect that we will have volunteer attorneys working on such complex litigation does give me pause. What also gives me pause is the authority that the compiler has to select, appoint, and administer. I do believe this veers perilously close to a legislative act, which I fear might create either an impression that I am shepherding or initiating, or worse, in this case, introducing legislation, when in fact my office is the impartial publisher of all Guam law. Those are my two concerns, and this again is just summarizing my written testimony. But finally, I would like to end with saying there is nothing preventing the legislature from adopting wholesale the Uniform Commercial Code as it is published on the Uniform Law Commission website. In fact, it is the goal of the Uniform Law Commission that uniform laws be adopted with as few changes in order to ensure and promote uniformity amongst the various jurisdictions that have adopted the UCC. I will end there, but I am happy to answer any questions as I'm able to. Thank you.
Tizos Masi. Judge Barrett Anderson.
Thank you, Madam Chairwoman and members of the committee. I became aware of the bill actually just yesterday when I was had a conversation with the compiler of laws, and I echo her concern for the compiler of laws' position to appoint as well as funding. I was a young college student when Senator Jim Underwood in 1977 got the Uniform Commercial Code enacted. And it was enacted at that time through the assistance of then compiler of laws Charles Trotman, and I believe what Charlie did that time was to take the model UCC, and by the way, Senators, there's the UCCC. So there's a UCC, and I believe the UCCC might be banking. I'm not quite sure, can't remember. So Senator Underwood put it on the floor, and the Model Act was adopted. And I don't believe there's really been much change since 1977, so I can go back to when UCC was first adopted. Having worked currently on the Criminal Law and Procedure Commission that was just formally adopted a couple of months ago and is now active since January. That commission is to review the Criminal Procedure Code and to go through the entire Title IX and Title 16 and anywhere that you have a criminal statute, to go through that and make recommendations in the next year to the Guam legislature. So I actually see this bill, Senator, as somewhat kind of following the path of the ULPRC. One of the things that I have noticed being an at-large member of that particular criminal commission is that there aren't very many lawyers that have the time to dedicate to a full review and redrafting of the statutes. Very, very hard. We have a lack of lawyers in the bar these days. We need to get more lawyers back into the bar. But I think the private bar is quite busy with either their corporate clients or working on criminal calendars and everything else. So I've noticed in the criminal law revision, the participation of members of the bar, there's not a lot. I'm retired, so I can come at any time. So I think that's going to be a concern for the compiler of laws. I would like to, and there's one thing that in my mind, and I'd like to encourage the legislature to think about, and the compiler had expressed it, money. You could easily go to the ULC, take the ULC, slap it on paper, pass it as a bill, and then have several roundtable discussions. Or you can give the money to the compiler and allow the compiler to contract either local attorneys that want to do the job, and they can do it in 1 year, but do a bid out. And these are lawyers, maybe corporate lawyers, that really want to do the work and get paid for it. I think I understand in here there's no payment here. If there isn't a body of attorneys on island that are interested in it, perhaps the compiler can solicit universities, law schools that might be interested in doing this for Guam, and then allow that product to be brought back here and then reviewed by a group that the compiler doesn't need a statute to call so many lawyers in and say, I've got something here. Or Senator, she can just, here's the product that the money produced. She's given it a review as a compiler, looks fairly good, send it over to the legislature, and then when it comes to your jurisdiction, you can call everybody in and say, well, how does this sound? How will this work out? Is it pretty good? So those are just my two comments that I wanted to make, one from my work on the current Law Revision Commission and its difficulty right now, and certainly my concern that the compiler of laws has a very meager staff. She could use like 4 more lawyers to do a lot of draftsmanship, but if that's your intent, then she does definitely need a whole staff of attorneys to help her with this obligation under the statute, if you pass it. Thank you.
Thank you. Chief Prosecutor Zona.
Thank you, Senators. So on behalf of the Attorney General, Douglas Moylan, I thank you for the opportunity to comment on Bill 8737. So this bill proposes creating advisory councils within the Office of the Compiler of Laws to draft amendments to Guam's Uniform Commercial Code in order to achieve uniformity with a minimal amount of variation from other states that have updated their own uniform commercial codes. The UCC was first published in 1952, and it's one of a number of model laws that have been established as law with the goal of harmonizing the laws of sales and other commercial transactions across the United States. And it's important because so many business transactions transcend state borders. And so in the past, it might have been a call to a vendor who would then deliver what you ordered down the street, and this evolved to the use of mail. And now we can think of ordering something online from Amazon and having what you ordered shipped from a warehouse in Texas to Guam. For the purposes of contract law without the UCC, if there were a problem, it could be unclear which state's law applied, where there were so many states involved in the process. So every state does have its own state laws. The UCC has been amended many times since its first publication, and adoption of the UCC really does vary from one U.S. jurisdiction to the other. with some states adopting part of the UCC, not others, some revisions, not others, more recent versions, not others. And sometimes the variation is due to alternative language found in the official UCC itself. At other times, adoption of revisions to the official UCC contributes to further variation. So, and in addition, some jurisdictions deviate from the official UCC by tailoring the language to meet their unique needs and preferences. So lastly, even identical language adopted by any two U.S. jurisdictions from the UCC may nonetheless be subject to different statutory interpretations by each jurisdiction's courts. In broad terms, the Office of the Attorney General supports maintaining updated legislation for commercial transactions, particularly where the law conforms to legal norms across the nation. While such legislation may make business transactions easier, from the perspective of interpretation and enforcement, guidance from existing legal precedent defining legal terms and interpreting provisions aids in our ability to enforce the law. So the Attorney General agrees that maintaining the legislature's ability to adopt model laws or variations thereof to accommodate conditions particular to Guam is fundamental to effective legislation. While we support having attorneys who are members of the Guam Bar on the advisory councils, we would suggest that the law allow for the advisory councils to seek advice from non-attorneys to determine revisions where such expert, non-lawyer advice assists the process. So this would include, for example, internet and banking experts to provide input as to how negotiable instruments such as checks are cashed in our new online economy. So on behalf of the Attorney General, Douglas Moylan, we thank you again for the opportunity to comment on Bill 8737. Thank you.
Thank you very much, Chief Prosecutor Zana. Attorney Michael Phillips.
Thank you, Madam Speaker and Chair and Senators. I don't think I'm going to speak too long. I think offering a perspective I never thought I would. I took Article 9 like most of you probably did, and those that went to law school. And I was pretty sure after that one semester I was never going to practice any secure transactions. Well, I have, and in the last 4 or 5 years, that's almost all I've done because of a case involving the government. And they nitpick every single portion of the UCC and say, but it doesn't say that. You can say, well, 50 states interpret it this way. Doesn't say that. And I suggest strongly that when it's written, that it's written for mom and pop stores and people other than myself, and their interpretation when they want it to read against anybody, to fight anybody, would be, for an example, A, B, C, D, and when you go to subsection C, it says C subsection 2. And so they'll say, but it doesn't say what you're saying here, and you say, but if you read it over here, it says it. And the power of the government is immense. I mean, I'm an attorney. They've held me up in court 4 or 5 years, and they'll continue to do it. And so the problem is, when you're writing these laws, if you write them down where it goes, this makes sense, I strongly suggest you don't write it like that. You write it in a way where mom and pop stores can say, hey, I wasn't sure about that, but now this makes sense. And that would make Guam fairly unique, because in most of the states, they're just written where attorneys will make sense of it, and there's such enormous case law and other interpretations by other states that everybody will figure it out. And most times, laws are written so that takes place. And what I mean is we adapt almost identical language from other states for that reason. But I'll tell you, the uniqueness of the UCC is it can make things flow very, very well, because everybody understands their liabilities and their obligations under the code. But it is really written for two people, attorneys that have good faith. And so I'm fortunate I've not been on the other side trying to take advantage of some small business person, but I could. If you look at that code, you could drive them nuts. And it's like, oh my God, you're kidding. You're saying that? Yep. They'll do anything they can. Anything they can. And I recently sent a few of you an example, an email that I sent to the Department of Administration, real simple. Attorney Jesse Lujan and others created the COLA certificate. So clearly a negotiable instrument. The testimony at the hearing was that it was going to be a negotiable instrument. And so it appeared, because of repeated statements by the Director of Administration, it appeared that the government had paid every penny, was his quote, every penny owed under the certificates and under the judgment. And so I believed him. Thought, oh, they're just singling me out. They just don't like me. So I beat them in every case. And then I realized, wait a minute. At the day that I won that case finally, I started it in '92 and I finished it in 2006. And the day that we prevailed, November 6th of 2006, 50% of my class had already died. I wasn't thinking about it back then. So who were the checks made out to? And so when Senator Lujan, because of the frustration of the government not being able to pay the balance of what was owed, created, it was ingenious. It was negotiable instruments that surpassed what existed under the traditional promissory notes that the government was entitled to give members of my class. And so with that COLA certificate, the COLA class appeared to be satisfied. And again, I didn't think, wait a minute, now 70% of them are dead. And I'll admit, I wasn't thinking that. So when they said, oh, everybody's got their COLA certificate, everybody's been redeemed, well, how can that be when there's only 30 or 40% of them alive? And so what would have had to happen is either probate or that law that I participated in that expedited for the heirs the ability to obtain either the checks or the COLA certificate payments. And so while they were doing this to me, it came up just a thought that, wait a minute, I bet you they didn't pay everybody. And I bet you they're just deliberately keeping quiet about it, hoping nobody will ever raise it. And you know it's a crazy idea. And guess what? The AG and Mr. Byrne and DOA, they refuse to respond to my FOIA requests. But there's one nice, good official in the government of Guam, and I don't want to expose who that is, but that person did respond. And over 400 COLA class retirees are still owed money. Over 4 million, not including myself. And they were just going to let them expire and go away and pretend that they didn't know. But how do you know that they knew? Well, I don't know about you, but if you pay 10 bills and you have an account and 5 of those checks were not cash, you'd know. That's number one, because I guarantee that the money that I uncovered that they owed was probably just a fraction of what they owed earlier and we're hoping would go away. Well, clearly, family members are going to find COLA certificates, maybe buried in a safe, or, some are so small it's not worth taking to probate. Or there might be other reasons, but I'll tell you, you're talking about numbers, some of them are $67,000, $77,000 or more, that honestly they were hoping not to pay unless they were caught. And I sent in the response. One of the responses by the Director of Administration was that there's a law that allowed him to destroy records past 5 years with the approval of the Attorney General. So the next FOIA I sent in was, well, show me that approval from the Attorney General. And the response was, oh, the Attorney General said that we're not going to respond to you because these matters are in litigation. And that's exactly what Senator Lujan and that legislature attempted to end, was continued litigation. Now, of course, understandably, when I brought my situation to some people, they said, Mike, well, does this affect more than you? And I didn't give a number, but I just thought, it'd be kind of strange. Everybody was able to work through this. And I said, well, this is the test case because they get to walk away from it if they beat me. And to my surprise, the numbers were astonishing. I mean, I never dreamed that they'd be trying to do that to over 400 people, over $4 million. Have you ever seen one ad in the newspaper saying, oh, by the way, Juan Cruz, you're owed $67,000, or Mary Jane, you're owed $70,000? No, nothing. But you'll see the tax debts for $67. And so when someone tries to tell me, oh, no, Mike, we intended to pay them. Sure you did. You fought me even to get their names. I'm class counsel. And they said, well, this matters in litigation. Which one they're talking about? I don't know. They'll say, oh, they're talking about mine. Well, then what does that have to do with those 400 people? They were fighting. And you know, quite frankly, senators, and I'll use the word generously, the audacity for a head of government to say, we have the authority to destroy that evidence. Are you serious? I mean, even the police officers don't say that in a heated case. They don't say that. Sometimes things happen. But you don't say, I have the authority to destroy that. That was their response. And so because they said they have the authority to destroy it with the consent of the AG, I asked for that. Now show me that. And that's when they said, oh, no, we're not going to show you anything. But there's one really good officer, and that officer's always been like that and cooperative. And they didn't know that I sent that person the same FOIA. And I got all the information. Over 400 retirees, which means that that's as of today. You can imagine how many people they were hoping would just go away. I guarantee the numbers are much higher than that. And even today, it's 4 million. I'm presuming under their accounting. And quite frankly, their accounting hasn't held up in court a number of times. It's been a little bit low. And so whatever it is today, I don't know. But take their word and say it's 4 million. But ask, gosh, don't you think those people should have known? And when you combine that with the fact that they sent me a letter saying that they have the right to have destroyed those documents, they didn't respond to the FOIA on time. I didn't do anything. I didn't take them to court. I have the boilerplate actions. I think I've taken as many people to court as any other attorney has on this stuff. But that's not the fight I want. But when I saw the numbers, I thought, wow. And they will fight them on the UCC. And Senator Long can correct me if that was not the intent. It was clear. It fits every single element. But it allows them to fight because, to some extent, it's in legalese, et cetera, et cetera, et cetera. And if that UCC could be drafted for the purpose of ensuring that this doesn't happen to other people, it would really, really help. It would really, really help. And if a mom and pop's, mom and pop store owner, I'm not picking on them at all or using them as a bad example. I'm using them as a good example. They're people that deal in business that are not always sophisticated and don't have attorneys on board and can't afford to fight people that just say, no, I'm not going to pay you. What are you going to do? And right now, like I said, you have a whole bunch of people that probably wouldn't know what to do and couldn't afford to do anything if they were told. And obviously, I doubt they're going to run an ad informing those people of the money that they're entitled to. I'm going to try and run an ad and let everybody know what they're entitled to. But that's just one example, senators, of the games that are played when you have a law that's intended, clearly intended, to benefit a certain person. You could call them a beneficiary. And I don't mean to single anybody out, but Mr. Fisher knows, for example, of government claims, how they don't doubt that you're entitled to the money. They just say that the court system is where you can't get it. And so there's a real misinterpretation, and people think, well, because Mr. Fisher, or Attorney Fisher in this case, for example, can't use the court to recover his money, therefore there's no debt owed. No, that's not true. The statute of limitations isn't about owing a debt. It's not about morality or anything. It's about the use of the courts. It's expired. You can't use the courts. But that doesn't mean, either in the eyes of the law or between the individuals, that the money isn't owed. Doesn't mean the government doesn't owe the money. Doesn't mean it's not a legitimate debt. It just means that the court says, you used Section 3, we can't do that. Like in my case, the district court has said, well, you can't sue your government. They can't hold that the government doesn't owe the debt. And that's what they're going to do to all those other people, unless we fix it and we make it crystal clear. And I don't mean to speak for Senator Lujan, but I'm willing to bet that at the time and the place that this was happening and those before him, nobody thought that the AG's office would come in and play these games. I mean, they didn't. Everybody was kind of on board, and the governor's office was on board, and everybody was going in that direction. I don't remember, Senator, anybody showing up to testify against it, right? Yeah, and so that's nice, but the problem is, as the years go by, and you have different people now jump in, and they're like, oh, we'll take advantage of this. And, you know, and I'm not singling out Attorney Fisher's client. I know them, and I know that's a relationship that often occurs with the government of Guam. And that is, you know, you work in good faith. They've never said you didn't do the work. And people misunderstand that and think that because the court doesn't allow your lawsuit, that the debt isn't owed. That's not true. It just means that the court says, hey, my level of participation here is capped, for example, at 3 years, or that. Or the government says, you know, you can't sue us after 4 years. They're not saying that you didn't provide the service. They're not saying we don't know you. They're just saying that we're not going to allow you to sue us after a certain time period. Of course, what the government claims, it's 18 months before you file and 18 months after. And, you know, some of you might be wondering, well, is this really connected with the UCC? Oh, absolutely. When you go through this, and I've had a number of senators tell me, Mike, that's real clear. And I'll tell them, it's real clear to you. But to the AG, when they get a chance to argue any way they can to defeat somebody that's owed money, using the UCC, they will do it. I'm very glad in working with the port. I had a GM that her goal was to make sure things were done right. And so we, as an example, had a gentleman, an older gentleman, that fell through a plank or something at the new Agate dock. It's clearly the government's fault. And quite frankly, the gentleman had no clue how to file a government claim. And we looked at it, and the GM looked at it, and she said, you know, do we owe this guy? And we said, yeah. And she said, well, help him. Because if we had taken the same position that the AG takes, I could have taken him on a ride for 2 years. He would have never gotten it right. Unless he went out and found an attorney. That would be wrong. The money was owed. It was the port's fault. There was negligence. Every single element was made. But the posture of the port, the posture of the GM was not fight everybody, not deny every claim, and see if there's any way we can find a technicality. That will be used in the UCC unless, we're not rewriting it. We're just writing it in a way, and that's why I was so glad to hear that this would be done. We're writing it in a way that big business and big AG's office, representing the government of Guam, can't take advantage of its own citizens with senators here trying to help. And I know you don't intend that, but believe me, it will be done if you don't make it very, very clear in the UCC what it's intended for and how it can be used. Because without that, you leave the poor citizens to just the language, which I would tell them, well, of course that means that. And if they ever made it to court, I think the court would tell them, yeah, that means that, but that's a long, expensive road, and it's really not necessary. And a lot of cases, and I'll end with this, there's small amounts that they just walk away from. They just walk away from. And it's a shame because the UCC is meant to make it super clear and super easy, and in the hands of a bad faith group of people, either big business or big government, they'll crush the average guy. They will. And so if you have any questions, I'll be happy to answer, but thank you for your time on this.
Thank you very much, Attorney Phillips. I begin with questions by the sponsor. Senator Perez.
Thank you, Speaker. I appreciate everybody's testimony here today. I feel like there are a lot of constructive criticisms that we can use to amend this bill. And so just to correct me if I'm wrong, it appears that there's a need for this. Is there a need to update the code? I mean, that's what I'm hearing from pretty much everyone hear from their testimony. I guess the issues is how do we move forward, and who hosts this change, right? Which agency is going to be the lead agency? And as far as when we create this code, do we tailor it to the little guy? And I think I'm in agreement with that. I think it's important to have, equity when it comes to our laws, and a lot of times there's a lack of representation for, the small businesses and those that don't have access to the information. So I do favor that perspective. In regards to, where this change is going to take place or who's going to host it. So initially when I was looking at this, I thought I could do it, right? I could do it out of my office, but it's just way too complex. It's a complex task. And I agree that contracting it out, considering our capacity issue here, is a wise decision, is a wise recommendation. Also, I guess the question I have for the compiler is, if we provided the funding for a contractor, is your office willing, and the funding for carrying this out? I mean, other than that, are there issues that we need to address, or should it be through, for instance, should we tack it on to like what's the revision for the criminal code, right? Or do we create another task force under the judiciary?
Thank you, Senator. These are insightful comments, and I myself know I need to tread very carefully because as I indicated in my written testimony, I don't want to appear that I am drafting legislation. If it is the policy decision to require the compiler's office to conduct this review, then I would comply. But giving my office the sole authority to appoint attorneys troubled me. And I do recognize there are limitations in terms of the contracting authority of the compiler's office, as we are part of the Supreme Court and part of the judicial branch. One thing I would like to, because we did just bring it up now in terms of contracting, that is an option, but I do recognize, I do read the Budget Act. There are also contracting limitations imposed on the government. So there are cases where I would not be allowed to contract unless there is a specific statutory authority to do so. If this was something that the body decided to keep in-house, to keep in Guam, recognizing, as you heard, the issues that we have special and specific to Guam, then I would say we need staff. We need experienced, we need subject matter experts. I would need help. I don't profess to be an expert at all in the UCC, and I would do a disservice if I said I could take this on my own. So I do recognize we do need expert help. Relying on local attorneys here, not everybody's an expert. Not everybody studies negotiable instruments or bulk transfers. If it was a decision of the body to put it in the compiler's office, I would comply. But I do recognize there are other alternatives that are completely within the power of this body. To contract on your own, perhaps to seek guidance, to seek reports, as was suggested, make it a joint project, perhaps with the law school, or even a sales or contracts class, to explore it that way. There are other ways than requiring the compiler's office when certainly, as I've indicated in my written testimony, dramatic amount of funds would be required.
Senator, if I might provide some background, the compiler of laws in 1977, of course, was in the Guam legislature at that time. And that's why the product came through the Guam legislature. And then the compiler was moved to the Attorney General's office. And then the compiler was moved to the judiciary. And so that's where Attorney Cepeda is talking about she does not want to appear because she is working within the judiciary, and judiciary should not be, judges don't ask for laws. Judges don't make laws, they interpret laws. So there's a little sensitivity there. If there was a body within this particular institution, in this branch of government, similar to a compiler of laws, whose job, and in fact, I talked to one of the senators currently on the panel, that there should be a permanent legal office in the Guam legislature that doesn't just turn over every 2 years, but is permanent. And if you had that permanent legal office whose job it is to write and draft those laws for lawmakers, then you wouldn't have to be reaching out through advisory councils and task force and compiler of laws, because you would have in this body a group of people whose responsibility it is, draft me a law. And then all you have to do, Senator, is say, here's the bill, here's the new UCC, I now open it up for public hearing, and I want roundtables, I want as many hearings as you want. Members of the Guam Bar who have the expertise, as Attorney Phillips here, to talk about what this UCC for Guam should be. So I think that's what I'm trying to say, is that compiler used to be in this body, and then it went there, and then it went over there. Does it have to come back here? I don't know. Or you create that own permanent body in this branch of government.
Therese Massey for that historical. Okay, thank you. Thank you, Madam Speaker.
Thank you, Senator Perez. I agree with that testimony. I very much support that any lawmaking is going to be done by the legislative branch, not the judiciary, who is charged with interpreting the law. And I know that there were exceptions made in the past, you know, different issues, but that is, I still believe, the goal. So, and I thank you for your suggestions as to alternative ways to pursue changes to the UCC. I just wanted to follow up with the compiler. Have you had the opportunity to actually look at the updates to the UCC? The note in the beginning of the UCC chapter says that there was an attempt in 2002, right? Public Law 26-172 repealed and reenacted Division 9 to adopt the 2001 revision of Article 9 of the UCC. Did not provide an effective date. So Public Law 27-40 amended Public Law 26-172 to add Section 5, which made the effective date October 1, 2004. Public Law 27-106 extended the effective date until October 1, 2005. Public Law 28-67 extended the effective date until October 1, 2006. The Division 9 provided below is pre-Public Law 26-172 and is the current version of the law. So my question to you is, was it amended effective October 1, 2006, or is it the version pre-26-172, meaning we never adopted the 2001 revision?
If I could, thank you, Madam Speaker. I would need to look at that specifically. I'm not prepared to answer it.
Okay.
But I could provide a report after
All
this
right,
hearing.
I would appreciate that, because it was my understanding that we adopted a revision since 2002. But the bill, in its intent, says public law, in the intent on page 2, it says something about, however, with subsequent repeal of Public Law 26-172, Guam UCC today remains unchanged in its entirety from the version adopted in 1977. And I'd like clarification of that. That's not my understanding based on this note.
I can follow up.
Okay,
From
thank
what
you.
I can read, it was a repeal of a repeal, and what happened after that
Okay,
is what it
please.
sounds like. I will check on that.
All right, thank you. And otherwise, I very much appreciate the other testimony here today as to the actual nuts and bolts of the UCC and what it's intended to do and what we're going to use it for, and how, if I think that would be ideal, of course, to write it the way that, as you described it, a mom and pop store would be able to interpret it. They're the ones who need it. They're the ones who we write it for. It's protection of, business transactions, right? Your rights in those transactions. So I very much appreciate the testimony.
Well, Speaker, if I could just add one point to that.
Yes.
The UCC initially was really designed to address the relationship between a merchant and a consumer.
Yes.
So the UCC, like any law, is not really designed to favor one side over the other. It's supposed to make it easy for those business transactions to go through. And today, we're talking about adopting down the road provisions that have already been drafted and have been vetted, so to speak, by a third-party agency, the ULC, which is looking at all kinds of jurisdictions and getting input from across the country from different experts, different folks that have studied these different issues. So while we always want to have laws that are accessible so that people understand them, the proposal here is, to a certain extent, to look at the experience, the input, the knowledge, whatever other inputs have been given to the ULC in order to develop those statutes. And that is one proposal that is in this bill. So there's been a lot of commentary today about things that, quite honestly, I'm looking through the proposed bill and I'm having a hard time seeing the connection. But just to go back to that issue about accessibility, the ULC has in fact addressed some of those concerns as well, but these are business transactions. So,
Yeah, you're talking about in the bill, it calls for, it allows the commission that's being created by this bill to recommend options that adopt the Uniform Law Commission recommendations, adopt those with variations, adopt recommendations other than the ULC Commission as well.
That's
so
correct.
It does allow them to go totally outside or to adopt no changes at all. And just to give recommendations, and as you testified, all the states are allowed to make slight changes in their adoption of the uniform laws. And we've done that in Guam since very many of our uniform adoptions.
and absolutely, and we support that. It's just I wanted to make the point that when we're talking about the UCC, the statutes have already been vetted when we look at what the ULC has said. So
I think the
there's a
issue that Attorney
tension.
Phillips was bringing up that I hear very much is that, yes, but when we adopt these uniform laws and they're not interpreted based on the explanation of the uniform commissions and we veer, that's when we're on our own on those kinds of interpretations. And apparently, I see in the law, the current law, that it says it should be, the explanations of the Uniform Law Commission should be used when interpreting this law, but I'm not sure that that's the case based on the testimony. But I'm not, of course, I think it's suggestive language to the courts, not mandatory. Yes.
Yes, thank you. I would like to clarify a point. We are talking about the Uniform Commercial Code through the Uniform Law Commission. There is a distinct difference between a uniform law, such as the UCC, as opposed to what has been kind of tossed around, the idea of a model law. A model law is guidance, whereas a uniform law through the ULC is designed to be adopted almost wholesale to ensure there is uniformity, as opposed to a model law where there can be some departures, and often that is expected. To ensure uniformity, there has to be as little difference as possible amongst the various jurisdictions, so that the interpretation of a provision in one would be the same as the other because they're virtually identical, if not exactly the same. So when we think about uniform law versus model law, we have to remember the UCC is a uniform law. I just wanted to make that clarification.
Right,
Thank
but the
you.
bill before us allows departure from that, right? So
Exactly,
that's
which
what we're
is
talking about.
Another concern.
Thank you.
Because then you would lose certainly that uniformity sought to be achieved.
Apparently, we have that already, so that's the issue. Okay, just one second. All right, Senator Fisher.
Thank you, Madam Chair. The first question I have would be to the compiler. We've been talking a lot about the we're talking about the UCC, which stands for the Uniform Commercial Code. Is that correct?
That's right, Senator.
Okay, there are many people who are watching us that may not know what the UCC is. Could you just explain to us what the Uniform Commercial Code is? And, I mean, you know it already, but it consists of at least 9 articles.
And there is a recommendation for new ones also.
Okay.
So I do believe Senator Perez did give a very short summary at the outset regarding the Uniform Commercial Code, or the UCC, as we've said, which is a body of law. It's a body of suggested law, a comprehensive set of provisions that was designed by a body of experts, law professors, practicing attorneys, who have come up with a set of uniform guidelines to govern business transactions, commercial transactions. As the acting chief prosecutor mentioned, transactions between vendors, merchants, and commercial consumers. So in terms of sales, what would be the rules governing sales? The Uniform Law Commission, with their experts, comes up with this Uniform Commercial Code adopted through the various jurisdictions. In fact, all 50 states and jurisdictions, territories, including Puerto Rico, Guam, and the U.S. Virgin Islands, have adopted either wholesale or with variations, the Uniform Commercial Code, to ensure that transactions in one state would be understood and choice of law would be apparent when there's a dispute.
Okay, I'm guilty of this too, but let's try not to talk lawyer, okay? Now, an example, if I go to AutoSpot and I want to buy an automobile, and the automobile they deliver to me is defective in some way, would that be a transaction that might be covered by the laws of the Uniform Commercial Code?
Under a contract for sales, Article 2 would be,
okay.
Exactly.
So these are laws that also govern our daily lives, right?
Yes.
So, for example, Attorney Phillips was talking about, I assume that the COLA certificates were some sort of what lawyers, here I go, lawyers might call either commercial paper or a negotiable instrument?
Negotiable instrument.
Okay, so Attorney Phillips, on behalf of his class,
And myself.
and himself, in conjunction, I suppose, with the government of Guam, they produced commercial paper, which were these certificates. It's just commercial paper. It's just paper basically used in commerce, such as that certificate. When he was talking about the intersection between the Lola Cola and the UCC, is that probably what he was talking about?
I understood that to mean just how far-reaching the UCC is on our everyday lives.
Okay.
It governs the checks that we are written, that are given to us, that we're owed. They govern sales in terms of transactions between vendors and merchants, and going to the car dealership and buying a car.
Mm-hmm. Okay. And just another example would be, I have a restaurant, and it's just doing terrible, just awful. And I'm racking up debts right and left, and I got to bail out. So I want to sell everything in my shop. I want to sell the oven, the microwave, and perhaps the food contents, and the chairs, tables, whatever, what have you. Is that what's called, potentially, is that what's called a bulk transfer? I want to liquidate everything.
You've hit me with Chapter 9.
I would say it is a bulk
I
transfer.
think it's like chapter 3 or 4 or something.
I am traumatized by the UCC in law school,
Okay. So if I want to,
Yes.
liquidate, get rid of my chairs, tables, food, ovens, etc., then the Uniform Commercial Code
Would also
will
apply.
tell me. So it'll tell me how to do it.
it would govern the transaction of how it happened.
Okay.
If not give step-by-step guidelines.
Okay, so the Uniform Commercial Code, it's not just some arcane law, it's the law that is it fair to say it is present in every citizen's life every day?
Whether they know it or not.
Yeah, because it governs our commercial life? Okay. The reason I bring that up is, good heavens, if you called me on the phone to ask me to be on this commission, I would hang up. There's just no way I'm answering your phone calls. Because I know enough about the UCC to be scared, and you know that old thing about, fools rush in where angels fear to tread, but somebody's got to do it, right? You're the man. I'm not the man. Absolutely not. So I'm pretty sure Mike wouldn't answer your phone call either. And then I've just got the commercial paper that you generated, the COLA certificates. Are they transferable?
Absolutely.
Oops, sorry about that.
Absolutely.
Absolutely. Are they?
I can help answer that as well. I'm the author of that.
That's right.
Okay,
You're looking at the author.
Okay, so they are transferable?
Yes.
Yes.
This is a slightly off the
In
subject.
fact,
but
they
has anybody-
initially hoped that they could be used to pay taxes and things
Sure.
like that, and the AG ruled that because of the organic tax, that was restricted. So with
Okay.
that condition, the AG approved them twice, I believe.
So, okay, the certificates themselves, they're transferable, and they were issued by the government of Guam?
That's
So-
correct.
So it's a note of the
Yes.
government of Guam?
No, absolutely.
It was to mimic the promissory notes.
Yep.
Yeah.
Okay.
And they gave a little bit more because
Yeah.
for whatever reason, the class was very upset with the promissory notes.
Yeah.
And so
Okay.
the senator came up with the COLA certificates, and they went over much better. But I'll tell you why, if I may, Senator Fisher, I believe, because they explained all the things that could be done.
Yeah.
Problem note's just a problem note.
Okay.
And that was it. But that actually explained you can transfer this, et cetera, et cetera, et cetera.
Sure.
But are you interested in hearing what the AG uses as the hang-up?
Well, hang on, I will,
I'll give you
yes.
the example.
But I had just a couple questions on the certificates. Were they payable on demand or at a
Yeah,
specific
see,
time?
that's a good example. Payable on demand is an example of a negotiable instrument.
Yeah.
But it didn't say payable, for example, on demand. So they say, see, it didn't say payable on demand. So if you look at the definition of payable on demand, it says, if it doesn't say payable on demand, it's payable on demand. So and that's not intuitive to people, but if it doesn't say it, it means it. Now, how do I know that? Because it's in the UCC.
Well, plus it also makes sense. If it doesn't say payable at a time, then that means it's payable on demand.
That's correct. See, to you, it's correct. To you, you understand that.
Right.
Right.
And are there
The
certificates?
AG's office can't understand that.
Okay, are there certificates out there that the government of Guam has declined to honor?
Oh, absolutely. That's why I've been in court for years now.
So the government of Guam is in default on all
Mm-hmm.
these notes.
Oh, yeah, and they're doing many other things we can talk about too.
Well, this is
yeah, it's really
just an
it's
editorial.
tragic.
Just an editorial, but that's unforgivable. I mean, this is the note of the sovereign. The
Absolutely.
sovereign has to answer.
Oh,
to
and
its
even just
own
the
note.
idea that they would go on record as denying it to be a negotiable instrument. Don't get me wrong. If they have a claim against me or they say I'm not entitled to it, that's fine. That just can't be one of them. And you didn't ask, but I'll tell you what their excuse is. They're saying because when I transfer it to you, you come down and register it. If you don't, you take the risk that I sell it to someone else and they register it. And they're saying that that's extra baggage, therefore it's not a negotiable
That it's
instrument.
not a note? I disagree with that. It's just, they're just going under a bona fide purchaser for value type.
Absolutely.
Okay, anyway, all right. That's surprising. I didn't realize that the government was defaulting upon its promises. I hope that.
Well, I guarantee you, Senator, they'll say, no, it's
I'm going to
tough
have to
luck. Those
object to
people
all
didn't
of
come
this
in.
characterization.
I'm sorry?
I'm just going to object to this characterization. I don't know that any of this really has to do with the proposal, but
Can we hear? I'm sorry.
I'm just going to object to this characterization of the government. I mean, we're not really here to litigate whatever this is that Mr. Phillips is talking about, and I would prefer that the group here let the courts decide whether the government is in default or not, because I think that's appropriate. not to
Okay,
litigate this
but I
here.
think-
Thank you.
I think-
I'm just making the record.
Yes, ma'am. But I think you'd have to agree that if somebody has made a promise and then welches on that promise, that seems to be a default. But maybe the choice of words could be different. All right.
I'm just saying this isn't the appropriate forum for that,
Okay.
but thank you.
All right.
So we're trying to change the law and rewrite it, and that's the invite. And
Yeah.
so the few times I show up on questions of law, it's because I want to contribute something that will hopefully convince you that it needs to be written a different way. I can give other examples. When General Anderson first came into office, I don't think I was the first person she called, but I had a fairly decent-sized case, and she called me. And she said, Michael, I'm ashamed. And I had no clue what she was talking about. She was talking about a case that the previous AG had fought and fought and fought. And it was real obvious that my clients were owed the money for land condemnation. That was it. That was it. And she said, is there any way that your client would accept the price that the appraisals came up with, that the appraiser came up with? And I thought, it doesn't get more fair than that. I just couldn't say yes because you have to consult your client. So I called my client, I called her right back, and I said yes. So depending on who's on one side or the other, those are the games that can be played.
Yeah.
But they're played both ways. I mean, don't get me wrong. There are attorneys, and in that case, for sure, General Anderson and others, where they have a different view of justice, and it's not just to fight every single claim. And I'll tell you, Senator and Attorney Fisher, what I really believe the methodology is, and the most tempting way to do it, is that misnomer, that misunderstanding, that if they can prevent you from going to court, they don't owe you.
Right.
And that's the way to do it. And you know that from the Lujan case, right? It's a travesty of justice. So the point is, now that you're able to rewrite the laws, do something to help Mr. Lujan, and do something to help the COLA class, and quite frankly, myself and others, because there's a lot of other people. And General Anderson may remember who that party was, and thank God she came in, because she resolved it, literally resolved it in weeks. And my clients had been in court having to prove, we actually had to put on 2 or 3 generations above my client, a witness that maybe was in her 80s, and had to testify about remembering her grandfather and uncle take her to these corners. Nobody else was claiming the property, but they were just doing everything they could to fight it, because that was the mentality of the person in charge. So when someone suggests, well, maybe this is better off in court, oh, heck no, because the laws are written many times so that they're left to attorneys and judges. But if they're, as we move along, written a little bit more so that the average person can not only understand them, but can use them, I think you would be doing a great service. And
yes,
I
sir.
hate to keep bringing it up, but that Lujan case sticks out as one of the worst.
I think the average person, sir, would say, if you owe money, pay it. Okay.
Yeah.
I'm going to wrap this up. Has anyone come in and tried to buy this outstanding certificates at a discount?
I beg your pardon?
Has anyone come in to try and purchase the outstanding certificates at a discount?
Yeah, you know, that's a really, really good point, because, and Senator Lujan may know more of this than I do, but when you have that certificate, and the government, for example, as they did, floated a bond to pay off all of that, why would you sell that certificate for 20% less? Yeah. Most people, your kids would say, Dad, don't do that, or you'd say, I'm not going to do that. They have the money. It's been appropriated. But when you learn that they're going to fight you, or they don't tell you, that's even better.
And this
then
is a class.
You either sell it at a great loss, or like I said, they're just hoping that nobody finds out.
Well, it's unfortunate, because this is a class of people who are elderly, and the debtor has a motive to slow down payment, because the claimants are going to disappear. All right, and then I'd just like to say that as to what Judge Baird Anderson was saying, I totally support the creation of something like a legislative research commission that is not subject to the whims of politics. It might cost us a little more, but it would help our practice significantly. Thank you, ma'am.
Thank you. It is done like that in many other states. Senator Lujan.
Thank you, Madam Chair. Thank you, panel. Thank you, actually, I didn't know all this was happening, and I'm glad you came and testified today, Attorney Phillips. And obviously, my question would be tailored around some of your testimony today. But Attorney Phillips, how can it be translated that the government doesn't owe this, and the reason why it evolved from a promissory note to a certificate is because, of course, the prom notes had its deficiencies as well, and the certificate was very clear in that this is a government debt, this is a government owing the people. How can it be interpreted that can I pay you? We don't have to pay you.
Well, I leave the government to respond to any other reasons that they may have that I forgot. The three that I remember, like, for example, in my case, they're saying, well, we settled that. And under the UCC and under the language that you selected for the certificate, it's very clear that the only way that certificate can be compromised is if it's redeemed.
That's right, that's right.
The UCC requires that there be some mention of it. So, for example, if you and I are in the back and you hand me $1,000 and I walk away and you claim that you settled my COLA certificate, then I get to ask, where is it? You say, well, you know, I didn't get it, but that 1,000 was for that. Okay, where's that mentioned? Well, I didn't mention it anywhere. And the other excuse they use is the statute of limitations. And so they use the statute of limitations, and in that case, they use that with me, but they also use...
But there's no statute of limitation
Exactly. Exactly.
In the certificate.
Exactly, and it's mentioned there. And it's mentioned there, and it's a continuing appropriation. All of it is you would think, right? And that's my point when you compare that to the raw language of a prom note or the raw language in the UCC, it requires further interpretation. Like Senator Fisher's question was perfect when he asked, well, about the payable on demand. And even myself as an attorney who took Article 9, right? I look at it and it's blank. And so when we're talking about the date, and the late Jyoti Sonagsi and myself both testified that it was a negotiable instrument, and he said, hey, give them a date to pay, that'll even make it better. Well, speaking as a layman, he's probably correct, because laymen are looking at it saying, hey, we got a date, kind of like we have to pay taxes in 6 months. But from a legal perspective, it doesn't matter, because in fact, when it's blank, it's payable on demand.
Sure.
But that's legal stuff, and you don't find that really even in the front page, so to speak, of the UCC. You would have to go to the definition of that. So in order to qualify as a negotiable instrument, one of the elements is that it's a date certain or payable on demand. Well, you won't find that there. There's no date certain, and it doesn't say payable on demand. I guess it's not a negotiable instrument. That's the government's position. The fact that you say that it needs to be redeemed and can only be redeemed, and that's really for the protection of the recipient by turning it in. They say, no, it doesn't. We can just, we can just pay on the side. And the UCC says that if you're going to compromise a negotiable instrument, you have to reference it. You can do it, but you've got to be very clear and reference it. There's no reference in anything, not a single shred of any mention of applying to a COLA certificate.
Of course, this case is the SP 0206-93 that we're talking about, the COLA, the COLA
The
class.
original one goes back to
the original case.
92 or 93.
But here's the thing that baffled me, attorney, is because Public Law 28-151 as well, as part of when GTA was sold, a part of the settlement with that, a part of the sale with that, was that there was a $10 million promissory note that was issued by Teleguam Holdings, basically, to pay for the COLA judgment.
Right.
I'm sure the government redeemed that.
Yeah, there's a number of things that happened. Senator, you may remember the floating of the bond.
Yeah.
And I don't think he'll mind me sharing, but I had asked the late, quite frankly, great Senator Pangilinan about the bond issue, because he was able to finesse it in a way where the government couldn't float the general operating bond, if I remember, that the government wanted, unless they floated the COLA bond. So I asked him, I said, Senator, could you go one step further and say that they can't pay anything over here unless they pay the COLA money? And you know what he told me? He said, Mike, you don't have to worry about that. And I said, why? He goes, because if there's money there, the government will pay it, because there'll be such a clamor. And yeah, you're right, Senator. It shocked everybody. I think even Ben's rarely wrong. But I think he misjudged, even Ben misjudged the administration.
Well, the genesis, again, as to answer Senator Fisher's question regarding the redeemable and has anybody sold it for a discount, one of the reasons why we introduced of course, the deficiencies of the prom note, and we clarified it through the certificates. But at that time, of course, the government had to take out a bond to holistically pay the
Right.
COLA recipients. But we also we didn't know what the total amount was,
Right.
with that. And so with the certificate, the redeemable certificate, and can be traded, it can be bought.
Yes.
And we know that the class that you represented was elderly. We knew that they were passing at a very,
50% of them had passed.
at very fast
By
rate.
the time you did the COLA certificates, it's more
and
like
so,
65%.
So one of the reasons why we crafted the certificate as such that it could be redeemable, because we didn't know how long it was going to take for the bond to go through, and we were losing the class at almost on a daily basis. So it was up to them. We wanted the government of Guam to issue the certificates right away. Certificates will be issued right away, and it'll be up to the recipient to either, because a lot of these elderly, they had medical bills that they needed to pay, and so if they wanted to sell it at a discount, 75 cents on the dollar, 80 cents on the dollar, that's up to them to be able to get their money as soon as possible, be able to do that. That's one of the reasons why we did that, because the class was dying out. I didn't know we had still over 400 of the class that still hasn't
remaining. Yeah, and some of the payments that are owed are very large.
And rather and
over $4 million right now.
Yeah.
But you can imagine what it was.
Well, here's
long ago.
Here's the thing, and I understand you're testifying in regards to clarifying the UCC to be even more clear. But I think in this case, we can clarify it through legislation to be even a lot clearer that the government is owed. And I don't know how many of those 400 that are still outstanding are still alive, but their heirs. It doesn't mean that their heirs cannot get that.
That's correct. That's absolutely correct.
Yeah. And again, it doesn't, how many people have bonds that they bought in 1950s and it's still good?
Sure.
So, it's not a note of paper that has an expiration date. And the reason why, again, at that time is the individuals can either redeem it as soon as possible with someone who may want to buy it and then later on redeem it for full face value, or keep it until the government has enough money. And that's one of the reasons why, because the government was strapped for cash at the time.
And you're right, Senator, the option was given, in fact, to DOA to reissue.
Yes.
Honestly, when you look at the veto message by then Governor Camacho, he wrote something that didn't mean anything to me at that time, because honestly, I didn't know enough, I guess, about Article 9 to know that they were actually payable on demand. And in his veto message, he said something that nobody responded to, because, quite frankly, he's probably getting good legal advice, and that was, you're going to bankrupt the government. Because technically, everybody could have walked over to DOA because it is payable on demand. But as you know, that's not what the class did. Yeah, not at all. And that's also why the interest was placed at a pretty healthy interest for that time, to encourage. And that's one of the things Senator Pangilinan told me. He said, Mike, we place the interest at this level so that when the auditors look at it and the accountants, they say, hey, you got to get this off the books. You just can't keep floating a debt like this when you've got others that are much lower. Get rid of this one now. And, like I said, what we didn't hear when people were saying, oh, yeah, we've issued all the checks, is that, well, who was coming to pick up the checks? Because at that point in time, 50% of the class didn't exist. And so by the time your bill came out, and was passed into law, the COLA certificate bill, about 65 to 70% of the class had already passed. And so then we crafted legislation so that we wouldn't have to wait for the person at the bottom, because that was the initial order. The lowest are paid first. And when we realized, hey, there's so many people that aren't going to be able to come in, you can kind of self-finance this. But everything was still appropriated. Everything was ready. But they didn't tell us that people weren't coming in to pick up the checks or the COLA certificates.
What the government needs to realize as well is the certificate comes with interest rates.
Yes.
Yes, so there's interest incurred over the years. So the redemption of these COLA certificates will also have, because we pass a separate bill to allow the interest. Why is it that when we owe government of Guam money, interest is incurred on us? And when the government owes you, you know, that therefore over the years that they do not pay interest now. So these certificates come with the interest bearing on it.
That's
so
correct.
yeah, so it's incumbent upon the government to pay as soon as possible. I mean, anyway, I would love to work with you to clarify this, because that bill was not, that law was not intended for the government to skirt its payment to the class. And although maybe I hope and pray that a great number of the 400 are still alive, but I seriously doubt that they are. But their heirs are still alive, and their certificates, whether they're issued to them or not, is still negotiable and with interest. And they probably still have maybe in their probates that they, you know, their estate, they still owe money to folks out there, and this could go a long ways to pay some of that debt that they owe. So I look forward to maybe working closely with you to clarify this, because it's, you know, it's that bill that became law was not meant at all that the government has an expiration date on that. Not at all. There's still a debt, and the government owes that. Thank you, Attorney Phillips. Thank you, Madam Chair.
Thank you, Senator Lujan. Senator Dueñas.
I think this issue's been litigated quite well, and I have no questions. Thank you, Madam Chair.
Thank you very much, Senator Dueñas. Sponsor may close on the bill.
I just want to thank the panel for being here today. Definitely going to take back a lot of the considerations that you brought forward, and maybe redrafting a new bill with this one. So I thank the Speaker for hosting this, and have a great day. Thank you.
Thank you, Senator. There being no additional individuals to present testimony, this committee will consider Bill number 87-37 COR duly heard. It's now 3:22 p.m. 4:22 p.m. We will now move on to the last item on the agenda, Bill number 51-37 COR. I would ask Senator Dueñas to please introduce the bill.
Madam Chair. Just real quickly, as this bill is another attempt, what was attempted in the 36th Guam legislature with myself and then Senator Tony Ada to present an opportunity, as the title to the act says, relative to allowing the construction of accessory dwelling units, ADU in parentheses, in residential zones. I think the purpose pretty much lays out what we're trying to do here. The purpose of this subarticle is to allow the homeowners to construct a residential accessory dwelling unit on the same lot as a single-family home located in residential R1 zones that allows adult relatives to enjoy independent living separate from the occupants of the main home. It is intended to be an affordable alternative to assisted living and to other senior home businesses that are not yet available on a scale to meet demands of Guam's aging population. And just in conjunction with that, of course, many of us know, and many of us in our own families know, that the current construction costs and housing, and just housing in general, is so expensive on Guam that many individuals are living in arrangements where they have multiple generations, families living in the home, but they have sizable lots to where they could at least scale right now to build additional housing that would have quarters that are suitable to house a small family or individuals along with the residential R1 single-family dwelling home. I know that there are some concerns with the bill. I did send it to the Guam Realtors over a month ago, and I'm glad that they've responded and made some recommendations. So today I look forward to hearing from all those present and see if we can maybe work on the bill going forward as well. But let's get the concerns put on the record. Jesús Masi, Madam Chair.
Thank you very much, Senator Dueñas. We'll now hear testimony on the bill. We have several people signed up. If you could join us on the table, please. Liz Dueñas, Georgina Campos, Libby Peer, Bistra Mendiola. Is there anyone else who's here who wants to present oral testimony on this bill? All right. Liz Dueñas, you may proceed.
Thank you, Speaker Therese Terlaje. Thank you for giving us the opportunity to speak. Thank you, Senator Chris Dueñas, for introducing this bill, because I feel that the bill addresses parts of our housing issues, and many of our people are moving out of rentals right now, and they're actually moving back with their families because the power bills have doubled, and many of us are feeling that, even myself. So right now, I just took an inventory. There are 262 houses available. 72 are pending. There's only 191 available. The rentals, there's 204 showing, but only 156 is available. Condos, there's 114 available. But if you look at the rentals, the housing sales, and also condos, those prices are targeted. A lot of us see that it's targeting military tenants. And even if we look for rentals for our local market, it's slim pickings. And even for Section 8 housing, there's some hesitancy in some landlords to take that. So it's commendable that you've introduced this. I know it was introduced before, however, it didn't pass. Hopefully, with some guidelines, it'll pass this time around. So I'm representing the Guam Association of Realtors, and I think what they did was just mirrored what my husband, John Dueñas, he submitted his testimony, and I'm sure my fellow realtors will have other feedback as well. We all have differences of opinion, and therefore it's good to collaborate and try to make this better. So Section 61140 revised the first sentence to read, the purpose of this sub-article is to allow homeowners to construct a single accessory home. This revision makes it clear that only one accessory home is allowed per single family lot. So this is addressing the comment. While the purpose of the bill is noble, the implementation and operation of the specific sections as written creates a slippery slope. That's John's words, which is highly corruptible and which will serve to defeat the original purpose of the R1 zone. This is not to say that the bill does not have great merit, because it does, and we all totally agree. However, it does point to the need to provide more provisions that will set guardrails to assure the ADUs meet the intended purpose, and not just another way to make money by creating duplexes in R1 zones. This section or follow-up section must put specificity in the legal purpose of the creation of the ADU, which this legal use be authorized upon application for a building permit backed up by the homeowner's recorded affidavit on the specified use. If there is another method or documentation that assures legal validity, which underpins the approval to construct the ADU. Section 61141, this section defines the ADU as a small apartment-like structure. This and subsequent sections 61142 should establish size limitations to put validity in the definition of small apartment-like structure. Section 61142 and looks like it's the same, expand B of section 61142 to specify that shared utilities may need to be resized or expanded to accommodate the additional loads, demands created by the ADU as determined by the requirements of appropriate utility agencies. Alternatively, rewrite section 61143 to address this provision clearly. And lastly, section 61144, what happens when at any time before or after the permit is granted or the ADU constructed, when the legal purpose is no longer valid and the homeowner wants to lease the ADU? This section specifies that a zone variance or a conditional use permit must be obtained. Which is it, a zone variance or a conditional use, or could it be a permitted use? If this is how the proposed law intends to deal with rental/lease of the ADU, then pick one. It's a sticky point. What would the basis for approving or denying a variance or conditional use application? So the other point I want to make is whatever it is we decide, just remember we're dealing with government agencies. I mean, going to EPA, going to the different agencies, what does it take? 6 months to even get a building permit. So whatever it is we decide, we don't want to put another burden on whoever is applying to do this, tie their hands behind their back. Many a time the government, sorry to say, ties both hands behind their backs and does not allow them to do the intended use. So I'm cautioning, however way we go through this, that we really look, if our intent is to help, then let's help. Let's not make it more difficult for our people. Thank you.
Thank you, Liz, and thank you to John for the very detailed testimony. I appreciate it very much. Georgina, campus? Oh, sure. Libby Pierre?
Thank you, Madam Chairperson and sitting senators. We appreciate this opportunity to testify on this bill. I think it's a very admirable attempt at what is very much needed on this island. We all talk about affordable housing, which is basically almost non-existent at this time on Guam for our people. It's, you know, we see all the time, every day, we have people calling us to find them a place to rent. $700 is almost non-existent. Anything more than that, you need at least 2 jobs, you know, or more than one person to be able to afford to live in any structure nowadays, you know, as it is. And so while I appreciate the attempt of this is to assist the elderly and family members, adult family members, I think it needs to extend further than that. I don't see why we are limiting it to certain people of age or, you know, has to be a family member. Why not let it be expanded to be able to rent it to other people? The need is there. We have a desperate need for housing here for, you know, people. Not only that, but with the cost of living, it's just really hard if you to construct a house and you get a mortgage for a $300,000, $400,000 house. If you got a mortgage on that, your mortgage is $2,500 to $3,000 a month. Most people can't afford to even have that right now. So why not help them out by letting them have the ADU that they can rent out that will help them to pay their mortgages? You know, I think that's also very much needed. The other issue that I have with this is where you need to obtain a variance or conditional use and go to the GLUC. That will take forever. You know, have you ever tried to get a variance or a conditional use? You know, you're talking a year at least. They have to meet, they have to have a quorum. It never happens. What you are doing is you are just stalling, you know, letting our people have affordable housing by putting that in. If you were just to get a business license, they have to come and inspect. They have to do all that. So why not just have it be a business license issued and let them be able to rent to whomever they choose? I don't think it should be limited to family members. And I think that will just help alleviate a lot of the problems we have. When you get a business license, you've got all the inspections that are going to come, you know, and so you're going to see it's to code. And the thing is, once you're able to permit it, and then the government is also going to realize revenue from rentals that are out there. So I think, you know, if we open it up a little further, it'll be a win-win situation. Thank you.
Thank you very much. Bistro Manjola?
Half of the senators, when I ran for office last year, I publicly stated on numerous occasions that I had a stack of bills that I thought should be reintroduced, and thank you very much for doing this, reintroducing that bill. It's critical to our housing market. It's been a while since I've been in a room full of realtors, folks. I was a former real estate agent back in the day, so I really understand what these guys are talking about. And I think that the more restrictions we put, the more conditions we put, it just defeats the purpose of having something that we're trying to do for our people. And currently, what my observation is, the people that need it the most are the youngest of our population and the elderly. Because right now, we probably have in each and every family, that you know, friends, you know, extended family, you have graduates, you have college students, you have UOG students that want to be separated, you know, they want to start going on that independence path, but they just can't because the housing market, as you just heard, is crazy. I've never seen rental prices like that. 2,200, 2,205, that's pretty much for a 3-bedroom, 2-bathroom, and 1,600 to 1,800, that's pretty much for a 2-bedroom, either a condo or a home. Yeah, $700, that was 23 years ago, and it's never coming back unless we do this. And I really appreciate that effort, and I hope that you listen to what the professionals are saying. I agree. And I also want to make a recommendation that we extend this zoning to agricultural. We have a lot more agricultural lots that are on the inventory of our land versus R1. Right now, we can build a duplex on a A zone, but if you try to obtain a separate accessory building that is not, for example, for agricultural purposes, most likely DPW is going to say, nope, we're not approving that. I mean, even obtaining a permit for a garage is going through hoopla of things. So please consider that. Thank you.
Thank you very much. Mr. Santos, did you want to testify? Please state your name for the record.
Yeah. My name is John Santos, and I'm here in support of this bill. This bill is going to give me an opportunity to support my daughter with special needs. I want to take advantage of this in extending or building another house to use as an incentive for a very hard-to-find caregiver. Yeah, so again, this would benefit me and maybe other people out there. Yes, I want to thank you, Chris. Also, I want to just add, it's not directly associated with this bill, but it's not directly, but indirectly. I've got a map here that has been registered and recorded at land management. And I'd like to build on this also, but we're having issues with permits because of the land size from EPA. Now, this map is a settlement through probate. It's a decedent subdivision map. If this map were to be titled parental subdivision, it would have been perfect. But because of our parents that had passed, we're not eligible under parental, right? So it's all approved. It's lots of 1,300 plus square meters. it's, I consider it a prime lots, and I'd like to build in it, but we're having issues. And if possible, you guys can come out with something and support me and others that are getting affected by this. There's 13 of us that's getting affected by this. So, yeah. If possible, yeah, I'm asking to be supported on this. Yeah. I don't see why can I be denied knowing, you know, we exceeded the minimum lot sizes for parental. And we can't build because our parents have passed. It seems like we're being punished for that. Yeah. Okay. So that's all I ask for, is to be treated at least the same way the parental subdivisions are being treated. Yes. Thank you.
Thank you, Mr. Santos. Georgina Campos?
I'm here in support of the bill also, Senator Dueñas. I can see that the intent of this particular bill was to provide affordable housing in some sort of way for local families and for any family that has made Guam their home to be able to build an accessory use unit that their family member can use. But and everybody actually brought up points in regards to the bill that I also wanted to bring up. Your bill specifically on page 1, it says that the single-family home accessory building will be located on an R1 zone. I wasn't too clear about why it was specifically targeting R1. Is it because right now the law restricts R1 to only a single home? Okay, but to B-stress point, most of our homes, most of the properties, I think a majority of houses, especially up north and south, are on agricultural zone. And I only asked that question about R1 because I wondered if maybe you put that intentionally because you were thinking about sewer lines. But if that wasn't the purpose, then I would also ask that you amend it to include agricultural zone, because on page 1 you have that it was to be located on R1 zone, but on page 2, 61144 says if the lot that the AUD is built on is zoned agriculture, which kind of led me to believe that it is possible to get a permit on the other zones as well. I mean, R2 you wouldn't need, but definitely A and R1. So maybe if you could just, to make it easier on people, because the problem we see is the bureaucracy of the government. When you go in and if the law is vague, and you go in and you say, okay, my lot's A, but it says if, then the interpretation, and I think Attorney Phillips brought that up, that it's based on the interpretation of the person you're standing in front of. And this brings me to John Santos's issue. His map is a probate map, ordered by the court, mind you, not something he came up with on his own, but ordered by the court, signed and approved through our government agencies. And the law says in order to get a subdivision map, which this is, it's a subdivision map ordered by the court, it must have been approved by all the agencies. It's the law right now. And on the map, it says that this map was approved pursuant to Public Law 28-126, specifically Section 1D. And in Section 1D, it says that as with parental subdivision maps, they're exempt from the need to have, they're exempt from the utilities or the infrastructure part of the law, that if you do a subdivision, the law says you've got to have this and that and the other. But the law was created to help decedent estates, which this is, and parental subdivision maps. But when it comes to the interpretation, when you have somebody new within our government agency, for instance, EPA, because for all these years, people like John were getting their probate maps approved by ordered, not approved, but ordered by the court, and they would then sell the lot or build on it, which is what John's trying to do at this point. But until we had an administrative change at the Guam EPA, which took place maybe 2 or 3 years ago, I don't know exactly when. Now we have a new person at EPA, and his interpretation, mind you, one person, his interpretation is, this doesn't matter because my interpretation is only parentals are allowed to have minimum lot size without sewer over the aquifer, but if you're not a parental and you're a decedent estate, we're not going to allow it if you're over the aquifer, because the law that the legislature created, and this particular individual told me this to me, the law that the legislature created did not specifically say that a decedent estate would be so that the lot size has to be a minimum of X. It doesn't say that because they left that up to the judge, and they left that up to the surveyors. These maps are created by registered land surveyors who certify that these maps are legal when they turn it into the judge, and the judge looks at it and says, yes, I concur these maps are legal, and I'm going to order that these maps be recorded. But now we have an individual at the agency, at EPA, and his interpretation goes against the interpretation of everybody before him, all the engineers, every government of Guam agency, who have already told Mr. Santos that if you come in, we'll sign your building permit. What's the point in applying for a building permit if you know ultimately EPA is going to say no? Not only that, EPA is using his property now as an example on their website. You see this map? This is an example of what we will not approve. But the law is very specific. The law says parental and decedent estates are legal and you should be able to build on it. But now because we have a person at the agency whose interpretation is different from everybody else's, I would ask, please make this clear and say if the senators agree and if the intent is to allow agricultural property owners and residential R1 owners to be able to build these accessory use, make it clear and put that in your bill so it cannot be left to anyone's interpretation. So, and then the other thing is I completely agree with Libby. If the intent is to provide affordable housing, then let the owner decide what they want to do. Why limit to family members? If John wants to turn around and rent his accessory building later to somebody who can only afford a simple 1-bedroom, then let him be able to rent it out so he could make money on that. There is no crime in wanting to make money and provide a good living and good livelihood to yourself and to your family members. It's not a crime. It is our dream for all of us to be able to do that. So maybe instead of saying if you decide to change the use and you got to go through Guam Land Use Commission, that's an act of God, frankly. And perhaps we could just say, get a business license like everybody else has to. I completely agree with Libby on that. And so I asked to go last because I wish that Senator Perez was still here, that she had stayed, to hear this, because we have been asking John and members of the Realtors Association, myself, we sent an email. Last year in May, I sent an email to everybody. I've called just about anybody I could think of. Liz and John have been emailing and sending letters about this particular issue, and we still have not been able to get the good senator to introduce the bill to adopt Type 4 facilities so people like John and anybody else, frankly, could build on their property that's over the aquifer in less than half an acre. I don't understand why we can't move that forward. And I still don't understand why John has to wait for that bill to move forward or to even get introduced before he can build on his lot. I don't get it, I don't understand it, and I was hoping today we could get Senator Perez's attention and the rest of you to support his cause and the cause of any owner who has a decedent estate. Thank you.
Thank you, Ms. Campos. I think you know that the scope of what you're requesting is actually beyond the scope of this bill, but we do hear it. I know that Senator Perez's phone and computer are here, so something must have detained her. I know she intended to come back to it and have left her phone. But I know those are all concerns relative to sewer versus septic tank, and that, yeah, they are being addressed in separate. You also told me earlier that you had consulted with the Lieutenant Governor, and we're waiting for his response as well. All right, but as to this bill, I'll let the sponsor start, and I also have some questions. Senator Dueñas.
This is Masi, and I just want to say at the outset, I think this is the third bite of the apple, so maybe it would be a charm. What I'd like to do, and just say this from the outset, I love all of the input. So I'd like to go back first and foremost and work with the Guam Association of Realtors, assist in drafting the updates to the bill, and then ask our chairwoman for a second hearing so we can all be clear on what we're trying to do. I think that's fair. I think it's the right thing to do. And I had a feeling that this would be a starter that would create this environment. The reason for the R1 zone selection is exactly what you thought it was intended for. This is the most sticking point when it comes to highest and best use of property, and that's why I agree with everything that's put on the record here today. One of my colleagues mentioned to me earlier, have you been in some of the areas around the island? And I said, yeah, that's exactly why this bill should be the vehicle to clean it up and to make sure that we come into compliance and that people don't feel as though they have to try to close the garage and do whatever it is and hope and pray or whatever the like is, or even a substandard structure. Let's make it uniform and let's be explicit, like Ms. Libby is saying, so that people understand and that now all codes are enforced and everything's enforced, and that's why I started with that. But I certainly have no problem, and I'll tell you why. Another thing for special purposes, like daycares and other things on lots that have been half acre or the like, and they've built structures that they've converted, many people have come to the Land Use Commission or came to the Department of Land Management, and as long as they expand their septic capacities to be to what the equivalent is of a normal household and with expansion, that have been granted. So just one more comment, Mr. Santos, and we do need to address this, and I'm glad you brought it today, because you should not be penalized because you didn't build your house before your dad died or your mom died. That seems ridiculous to me. So I would like to also make sure that when we do that, and then we can go back to what the requirements would be in the event that the dwelling units are sized properly, so that they're conforming to what septic requirements until government can get its act together finally and get sewer in areas where it needs to be, particularly in subdivisions, to make all of this stuff go away and just do it right. But in the meantime, I think we can fix this bill to make it expand and do what we want it to do. And I thank you all for being here, but you have my ultimate commitment to go back and draft the sections more broad so that we can fix it. But I think it would be important for the community to once again hear one more public hearing on this as we would introduce that so that it was clear and there would be no ambiguity on the floor. Because I think we need to pass this, but we need to get it right. Because it would be a shame if it sat in committee and nothing happened to it, or that, what has happened in the past, or that, it goes to the floor and there's so many reasons to just kill it, Because I think this is so vital as represented by GAR today. And so I think that I'm willing to take the time to get it right, but I think the people of Guam deserve this and deserves what's intended here to be able to get this done. So, and Mr. Santos, and it wasn't designed, Libby, the write-up there shows the possible uses, but it wasn't limited in terms of just because of the fact that it's for Monomco or other things. It is really for the purpose of whatever intended use. And Mr. Santos, I think you're absolutely right. So many people are in that situation where they have caregivers but the caregivers would also look to those units that are standalone for the day when you're out working and your family is all gone and they're in that unit and they take care of that family member. And then at night when family comes home and the like, you bunk with them and everything else. There's so many, it's so utilitarian, really, this proposal. So thank you for wanting to make it better and to clean up possible issues that already exist. I don't have any questions because I'd like to just work with you on it. And I think that's the better way to do things, is to do what we need to do to fix it. But Liz, I guess I have one question. Do you at least agree that the fundamentals are here and we can fix this and this is not a deal breaker as long as we go in and enhance the sections?
Yes, and let's be clear so that when it does go before any permitting process, that they don't hang it up like they're doing now. I mean, so many things are going on. I mean, like Mr. Santos here at EPA, it's subject to interpretation. That's our problem right now. So please, we got to make sure they don't hang us up, because then it defeats the intent and defeats what we're trying to do for the people.
I think I thought I was trying to get around that by being simple. Bad on me. but no, really, I mean, we thought the language was strong enough as a standalone, but I want to make sure that we get around the hang-ups and the things to where it's clear when the permitting process goes forward. And lastly, in the last section, the reason why, Libby, also, because I've done this as a director, I felt bad for families. The director has the power, and this is why the conditional use was put in here, or the options. You guys know this, and you've dealt with this in the real estate industry. The director has the power to, with a single scratch of a pen, make legal a legal non-conforming property. And a lot of times that's done because there's hardship. I've had people come before me where they're elderly couple, somebody needs medical care, they're trying to refinance their home, it's a beautiful home, it has a lot of value, they have a really small mortgage, they're trying to refinance, and they built a little something for their child, and yeah, they put a little kitchenette in there and whatever else, and it's on the side, but the bank says, man, we want to give you this loan. You got plenty of equity, you can service it, everything's there. We're not going to do it because, you know, this little situation here is something that we will be holding the bag for if the mortgage wasn't. But sometimes because of the authority that's issued and the bank says we want to do it, and I run it through all the planning committee and everything else, I said, this is no problem, sir. We signed that letter. Every director signed several of those letters under hardship. So that's why I was trying to make it through that situation. But I think you're right, Libby. If we just make it clear that that's an available instrument, then there's no question and there's no application process. You can use it for that use. With that, Madam Chair, thank you for the opportunity to engage the panel.
Thank you, Senator Dueñas. Yeah, I was going to also point out, so there was a previous bill that came through the legislature, very similar, to add on, to allow ADUs to be added on. And that came through my committee as well. It did not get out on the floor because there were very many concerns. One of them was constitutional concerns because of how they designated or delineated who could use that facility. There were also many comments from the Department of Land Management, which I'm very happy to hear today, are similar to what's being brought up by the realtors themselves. It's got to do with, some of these lots they're different sizes, right? The R1 lots, a building, so he recommended a building footprint limitation be considered. Some R1 lots are as small as 500 square meters, unsewered, that we consider minimum lot sizes in unsewered locations, that the utilities, and so this bill has said that the ADU complies with the standards set by agencies responsible for utilities, so I think that's workable. On another section, however, it says the ADU may, at the option of the homeowner, share electrical, plumbing, and data, and I think that's where some of the issues might come in, whether it can accommodate that, right, with the existing footprint. DLM had also brought up the taxes, whether real property taxes should be affected. They brought up that apartment-like occupancy can be presently applied for with a conditional use permit application for a duplex in an R1 lot. And I wanted to ask you, what is your understanding of how this differs from a duplex? Attached or non-attached, maybe? Is there any other way?
The duplex is usually allowed within a zone. It's not allowed in an R1 zone. So R2 zones allow for duplexes, but not in an R1 zone. However, in the north, you're going to see duplex, triplex, all in an R1 zone, and they're collecting rents, but I don't know whether revenue tax is monitoring or any fines or penalties are given, but it's kind of like a common thing you're going to see in the north.
And if this was, if we allowed them to charge rent, or, right, how would this be different than maybe those short-term rentals that we also talked about in another part of the statute, like, well, they have Airbnbs and then short-term rentals, right? If the breakfast is separate.
The intent of this is basically to allow, like we just had a renter move back home to their parents. They couldn't afford the power bill, so they had to, and their rent was only $1,200, but they had to vacate because they couldn't afford it. So the intent of this is to help these people, and also people who have low income, and they can't, some of them aren't on, these are locals who are not on Section 8 and can afford $500, $600, $700 per month for rent. So I think the intent was to address that.
Well, that's the point for me, yeah. I totally agree with the intent, all for it. I suggested to the sponsor, yeah, we've been looking at the Hawaii statutes. They're very detailed. And so I feel like the more detailed in this case, the better, because then no interpretation's necessary. We've laid it all out. And so I favor a little bit more detail.
In the States, they refer to it as casitas, where you see that in the States, where the in-law suite is in the back.
Yeah, and so they're very specific, for example, in Hawaii, about who's going to stay there and for what purposes. So I think that's how they distinguish it between short-term rentals and other types of facility, right, where it's being for commercial purposes. And then in this bill,
point of information real quick on that, Madam Chair. Madam Chair?
Pardon?
Just a point of information on that. We have local statute on Airbnb and short-term rentals. Now, that's a revenue tax issue.
That's what I'm saying.
Yeah, so what I'm trying to say is that this is, if that were the case, then somebody who owned this that wanted to use that for that would rework to the statute that exists already that should give them that designation. It shouldn't be thought of as though this would be circumventing that process. It's our obligation.
No, I think it's, yeah, that's why I'm bringing it up, Senator, because we need to make sure we don't do that. And that the language, without very much more specifics, I think it's open for that, if it's open for rental by anybody, right?
But we have a statute for that.
I think it's either that or in the bill, you can probably specify that the intent of this bill is not for short-term rentals or Airbnb.
That was my next point, yeah. So the purpose is stated in the bill as a purpose, and I think that's where a lot of the maybe just difference in opinion comes in. The bill is being discussed sometimes with its purpose, but the purpose is really not binding at all, right? It's like a legislative intent, but it's not repeated anywhere as a hard provision in the bill. And I think that was also brought up by the realtors. So, yeah. So for me, that's where this, whether it's R1 or not, is clarified, that we put it into the actual content, the zones, whether it's zoning or conditional use or neither, right? And just allowed in those areas already. Or it's, and then whether it's for adult relatives or different, right? Yeah, so I would just like to clarify those. I would like to address the concerns brought up by land management as well. And so I'm glad to hear that the sponsor's willing to work on those things. And again, thank you all for your testimony. I think it's very helpful. Mr. Santos, I hear your testimony. I'm not saying I'm not going to address that, just not on this bill, does not address that, but your intention to build you know, an add-on, an ADU, so that you can address a caretaker. I hear that, and I want to consider how to accommodate that with this as well. Senator Fisher?
Thank you, Madam Chair. I just have a comment on the bill that Senator Christopher M. Dueñas has introduced. I like the bill. I support it. And a couple of things I like about it. You, through this bill, are attempting to provide security and a feeling of safety to a vulnerable population, which is our elderly. And as their life unwinds, they will, you know, be able to stay with their family. They won't be going off to some care facility, and they will enjoy the sense of permanence that they're entitled to. So I like that very much. And I also, this is the first bill I've seen, of course this is my first term in the legislature, that is attempting to address, and this goes, I think, to Ms. Pierre's point, this is attempting to address the prohibitive cost of housing on island, which is driving people away. And this bill addresses two evils, and I like it very much. And I understand that it may go to a markup, and other things may happen, which is good. But I do support the bill, and I would congratulate the author. Thank you.
Thank you, Senator Fisher. Senator Lujan?
Thank you, Madam Chair. Thank you, panel. Actually, I support the bill heartily as well, and I thank you for coming this afternoon as well. I know the author had responded to this from over, not just talking to homeowners, but also realtors, and almost on a daily basis as well. We get calls similar to this. How can we do this? Everything is we cannot do, right? And Ms. Gina addressed the fact in regards to the septics, and I think it was just last week where we had a confirmation hearing for a EPA board member, and we asked him as such. And he was truthful in the fact that he's new to this, but he understands the situation in regards to families building homes and not being able to build it because, you know, they're over the, what is it, the water protection, yeah. And so, but we're excited that he want to work on it, and of course the oversight chair, and we're working, actually our office working closely with the EPA in regards to that deficiency as well, to try to correct that, because it's much needed, and also working with real estate folks and all that. But EPA is, they're all in support of that, but they just need the law to solidify it, because otherwise they won't be able to.
Senator Lujan, we've been told that for a year now.
Oh, really? Okay.
Yes.
Oh, really? Okay.
Yes.
Well, okay.
Make
Since
it
last
2-3
May.
years.
3 years?
Well, I mean, particularly about changing the law to accommodate the nitrate reducing system.
Yeah.
That's what we've been told for a year. But to reinterpret the law so people like him aren't affected until the legislature has the opportunity to address and create the law to allow the nitrate, that's a separate issue altogether.
Yeah.
Yeah.
Okay.
Thank
Well,
you.
I know we're working closely with EPA, and yeah, we're not tolerant of we're going to do this tomorrow. And tomorrow is tomorrow. It's 24 hours from today. Okay, not next year, not 365 days. So if you give me a date, I won't bug you until that date. But don't tell me tomorrow when you keep telling me tomorrow, because that never comes, right? But thank you very much, because again, one of the reasons again that I hardly supported the nomination was that he's open-minded, and the fact remains that he knew there was a problem, and that he's willing to address that as well. So again, I'll give him all the opportunity to do that. But please, I didn't know you were working on this for the past three years. But yeah, no, I think you see the fact that this legislature is a can-do legislature, and we definitely we're going to be on top of this. And like I said, I have my chief of staff who's almost on a weekly basis up at EPA, and if it's not one thing, it's another, and likewise your building permits, the one stop is Bula stop. Bula mini stop.
I'm just going to warn you right now, that sounds like an invitation for us to come and visit you.
You're welcome. You're welcome to come you're welcome to come to our offices because the three of us are there all the time. But thank you very much, panel. Thank you, Madam Chair.
Thank you, Senator Lujan. So I look forward to the revisions that might be proposed, and we'll determine whether we need to have another public hearing or they're similar enough or before we move forward, Senator Dueñas, and I thank you for that offer. And so I'll let the sponsor close on the bill, please.
Madam Chair. You know, I just once again want to thank the panel for all of the input. I think that Senator Fisher hit the nail on the head. The bottom line is that I'm glad this came to light, that there is a dual purpose, maybe a tripart purpose of this, that really affordable housing is the key. And it's not limited to, but it's, of course, the first noble effort is that we take care of our own. I know there's big options for assisted living and the like, but on Guam, a lot of us still want our loved ones right next to us, but we want to give them the dignity. But beyond that, there also is the dignity of other family members who are starting out in life that might just need that unit also to have their privacy when they're staying with their family members and parents. And then finally, you know, let's just be honest and put it on the table, right? There's a lot of need in our community. The need is overwhelming. And so let's specify what this unit would be. And if it's going to be a rental, it's going to be a rental. And let's just be clear and make it known. And make it known that it will comply with all standards that exist, business license, more revenue for the government, more revenue circulating in the family having that disposable income now, or they can pay their bills and maybe not lose their house. So it's so critical in terms of what. So I look forward to the coming weeks and months. We're early in this term, and I'm glad I introduced this early so we can get it done. But I think it would be a disservice not to fix this bill and get it out right away. So with that, Madam Chair, thank you for your willingness also to work with us on this, meet all the requirements, but get the job done, because this is a game changer the way I see it. Sijus Masi.
Sijus Masi. There being no additional testimony, we'll consider this bill duly heard. It's 5:10 p.m., thank you. And you may continue to submit testimony for the next 10 working days until Wednesday, May 3rd, here at the Guam Congress Building, or to my email at senatorterlajeguam@gmail.com. This hearing is adjourned. Sijus Masi.